I'm gonna take my phone up to it.
You want me to start the video?
Yeah. So this section is, the next section is about building estate planning and building legacy. Oh, that was my word, y'all.
You want me to?
I didn't share my word, but legacy was my word.
Are y'all? Take a break or anything?
You want me to let her in?
Yeah.
You said she's a lawyer.
She's a lawyer. She is a licensed.
She gonna get me out of jail. I killed my baby daddy.
Well, she is a financial lawyer, so probably not.
Hey, girl.
Hello.
Hi. We are still getting set up. We just got finished with a workshop, which was amazing. I believe. So I need to.
Awesome. What was it?
So it's finance and budgeting. Ladies, what all did you cover?
Everything.
Everything.
Credit.
So I'm about to log in so that you can see the ladies.
You want to sit right here?
And I have a PowerPoint that if I'm able to share, I'd like to share and go through.
Yeah, I'm gonna make you the host.
Okay, awesome.
So just give me 1 second. Let me just get myself.
No rush.
I said, it was so perfect that you were running a little bit behind.
Yeah.
Because I had to go find someone and I was running behind too, a little bit. So I am.
It all worked out.
It worked out perfectly. All right, so you're gonna be able to see the ladies that are here.
Awesome.
And I'm gonna make you the host.
Okay, great.
I'm getting there. I'm getting there. It was a minute. It took a minute though. All right, let's see. Oh, I know what we need to do. Then where is? So Samantha, I want to tell them a little bit about how I met you.
Sure.
So I decided to be a grown-up and develop a legacy of a will and all that kind of fun stuff for my children. And so Miss Samantha was the lady, the lawyer who got me set up. And so I'm really, really grateful that she's a part of my journey in terms of establishing legacy for my kids. Because I think that with any mom, like your heart is to make sure that your kids are okay once you leave here. So Samantha's going to talk to us about all things legacy, estate planning, all those fun things. Are you frozen, Samantha? She is. Right.
Awesome.
Okay, can you hear us?
Frozen?
It's going in and out.
Am I breathing now?
Yeah, you're going in and out.
Okay, hold on.
And I know you can't see me, but that's okay.
How about now?
It's fine so far. I'll let you know.
Okay, just let me know. Hi, everybody. My name is Samantha Gordon. I'm an estate planning attorney. I'm located in Charlotte, law firm Jones and Whitaker. I primarily just do estate planning. And as your lovely host said, I helped her with her estate planning as well. So what we're going to do for this workshop is I have set up a PowerPoint that will go over just legal strategy, organizing your estate, and things to think about if you have done a will, or if maybe you've done a will before and you're thinking of changing it. So I'm going to share screen now. And let's make sure that we can. Here we go. Can everyone see that?
No, not yet. You gotta share screen. There you are.
I'm sharing on my end. Okay,
I think it's starting. There,
awesome. So you guys can see it?
you see it now.
Okay. So like I said, we're going to talk about legal strategies for organizing your estate. So first off, I wanted to start this little cartoon. It's a little bit of an estate planning punny cartoon. It's a turkey talking with a lawyer, and it says, with Thanksgiving around the corner, I thought this would be a good time to review my estate plan. So what is estate planning? Planning and arranging your assets to achieve your goals during your lifetime and after you pass. So there's an emphasis on the management of assets during your lifetime through estate planning. There's also, you're going to decide the disposition of your assets after your death according to whatever your wishes are. There's also an avoidance of attorney's fees, court costs, and delays in managing and distributing your assets. You do have an estate plan in place. And then also the reduction or elimination of taxes that would apply for your estate. So what happens if you do nothing? So you don't have an estate plan in place and you pass away. Well, a guardianship may be necessary for either your children, if you leave assets to them and there's no one there to take care of the money because you not name someone in a estate plan to take care of that money. If you get sick or you become incapacitated, then you'll need a guardian to be appointed for you to take care of your well-being, your personal decisions, because now you're in a place where you make your own decisions and you don't have a legal document that states who makes those decisions for you. So now a judge gets to appoint who that person would be for you. If you have a document in place, you chose that person and you know who's going to be making those decisions for you. A guardian can be appointed to make personal and financial decisions for you. It involves fees, it involves delays, and it also can take away your control and your dignity. It can be very public and stressful for both you and your family. And there's really no guidance for your family or court about your wishes because you don't have a legal document in place saying what your wishes are. It's just this person that's being appointed as your guardian by whatever judge at the time it is that's making these decisions. So that could be detrimental to whatever your wishes would be. On top of that, so if you pass away, your assets are going to pass through probate to the beneficiary that are assigned by our state statute. So that may be different from who you would want your beneficiaries to be. And in your will, you can bypass the state statute and you can say exactly who you would want to inherit from your estate. The probate court supervises the distribution and everything becomes public record if you don't have a will. Possibility of significant fees if you don't have a will or trust. It may involve multiple probates. So probate, just to explain what that is, that's what happens after you pass away. So your will gets filed at the courthouse and then an estate is opened for all of your assets to be transferred to your heirs. So that's what probate is. If you have property in different states, it's possible that multiple probates will have to happen because now we have a probate happening in North Carolina and you own some property in Las Vegas, and now we have to have a probate estate in Las Vegas to handle that, which means you're hiring more attorneys and you're paying a lot more money than if you would have had an estate plan in place that defined what would happen to these assets and who would manage these assets for you. So what type of assets are included in your estate? That would include any real property that you have, if possible, stocks and bonds, your checking and savings account, if they're just individual accounts and you haven't named a beneficiary for those accounts, possibly brokerage accounts, insurance accounts, retirement accounts, and personal property. So personal property is your tangible personal property, vehicles, furniture, clothing, jewelry. So all of this can possibly be part of your estate. Some jointly held assets could be possibly part of your estate, but it just depends on how they were owned jointly. So type of assets are typically not included in your estate. So life insurance, typically when you open a life insurance policy, you get a for that life insurance policy. And Carolina law, you have a beneficiary named for a life insurance policy, that money from that life insurance policy after you die will go right to that beneficiary. It's not part of your will, which is beneficial. So if you do have life insurance and you haven't named a beneficiary yet, I definitely recommend that you do that. Same thing for retirement plans. Typically a 401k, an IRA, a pension annuity, something like that, that also has the option to name beneficiary designations. So I would recommend that you also make sure that you have beneficiaries designated for that as well. Jointly held accounts with right of survivorship. So if you have an account that you own together with someone, say a checking account, and it's with right of survivorship, that means if something happens to one of the individuals on that account, so you or the other person, the survivor is automatically entitled to that money in that account. So typically that does not pass through your will because the survivor is entitled and they get that money. Same thing with property. If it's owned tenants by the entirety, that's as a married couple, typically whichever surviving spouse is alive, that's who receives the property. If you own any property joint tenancy with rights of survivorship, it's the same concept as the bank account. The survivor is entitled to that property in the event that something happens to you. Avoid, anyone that maybe you wouldn't want to receive from your estate to get your estate, avoid this whole guardianship proceeding that I previously talked about. You want to create a will. You want to create a durable power of attorney. So a durable power of attorney and a healthcare power of attorney and a living will that avoids someone having to be appointed as your guardian in the future, because the legal document states who makes legal decisions for you while you are alive, financially or health. There's also establishing a revocable living trust. All of these documents we'll go through a little bit later on in the slide. Take advantage of other strategies. So like I said, beneficiary designation, making sure that you are doing those. A good estate plan typically utilizes all of these tools. You have the estate planning documents, and then you're also making sure that your beneficiary designations are properly designated. So I made some slides explicitly for single moms. So estate planning for single moms. These are some things that I want you guys to think about when you're thinking.
We lost her. Yeah. When she comes back in, it will tell you that she's coming in and you just have to end there.
Okay, thank you.
Her connection was showing. And you might want, can you pause the recording?
It dropped off there.
Oh, there we are. She's back.
I don't know what happened. It looks like I just dropped off.
Okay, well, we have.
Okay, let me.
We can hear you.
Okay, awesome. I need to be made the host again because it won't let me share my screen. Where did I cut off?
Click on her name, and then you just say more, and then. So you were talking about tips for single moms.
Okay, yep. So I didn't quite start that yet, so that's good. Okay.
What happened?
You got that again?
Yeah, she dropped out again.
All right, great. Everyone can hear me and see live? Can you all see the slide and hear me?
We can hear you, but I can't see no slide.
The slide coming up.
Okay. Maybe it will take a second because it's on my screen.
There you go.
Okay. Technology is great until it's not. So the slide that I wanted to talk about is estate planning for single moms. So I specifically wanted to touch on some things that you guys should be thinking about. So guardianship. If you have a child, do you have joint custody? If you have joint custody, legal custody or physical, that means that if something happens to you, that other parent is the next legal guardian for your child. If there's any reason why you don't want to nominate that other person as the guardian, in your will, you have the opportunity to state who you would want the guardian to be. And what would happen is your will would be used as a suggestion and evidence to the court stating who you want the guardian for your child to be. So in my opinion, I think that's one of the most important things to think about and why you should have a estate plan in place if you have any younger kids. If there is no other parent, or if you have full custody, then that's another reason why you would want to have someone listed as a guardian in your will, because now you are telling the court who you would want to be the guardian of your child. If you don't have any type of document that says who you want the guardian to be, well, now we got a bunch of family members going to court and the judge is deciding who the guardian is going to be. And you may have family members who you know cannot take care of a kid and you wouldn't want them to take care of your kid. So that's why having a will in place that has that specific provision that states who the guardian is very important. Also, another thing to think about is, are you divorced? So if you have been divorced and you have documents in place previously, so say you did a will with your previous spouse. In North Carolina, once you get divorced, your spouse is automatically disinherited through your will. So that's good news. However, if you did a power of attorney, so a financial power of attorney or a healthcare power of attorney with that ex-spouse, that is not revoked. So you need to update that document. If it still has your ex-spouse on there, your ex-spouse technically still has legal authority to make those decisions for you. Same thing with beneficiary designations. If you had your ex-spouse as primary beneficiary for life insurance or retirement, you have to change that and take them off, or technically they will be entitled to those assets. If you get married after you've completed documents, so say that you've already done documents and then you get married, I would contact an attorney to revise the documents with your new spouse. There's something called an elective share in North Carolina. It means that if a spouse is not included in another spouse's will, then that spouse is entitled to a share based on the years that they've been married and the net assets in the estate. So that means you technically cannot disinherit a spouse under your will. So if you do get married and you already have documents in place, I always recommend that you meet with an attorney and look over those documents to figure out and make sure that your estate plan follows what your wishes are. So another slide is, do you own a business? So business succession planning should also be part of your estate plan if you have a business. So it can provide assurance that a small business remains in operation after your death for the benefit of your kids. The business can continue to offer income for your children and be preserved for your children to inherit possibly. This can be done either through a will where a trust is under your will or just through a trust document itself. Business succession planning can also provide an efficient process for closing and liquidating the company after death. So depending on the situation, closing and liquidating the business might be in the best interest for your children. So with business succession planning, you can name who handles that for you and for the benefit of your kids. So let's talk about the documents that you need. So I've been talking about them. Let's actually go over what they are. So your durable power of attorney. So this document allows you to designate an agent and provide instructions for handling your personal and business affairs if you become incapacitated, incompetent, or otherwise absent. So basically what you're doing with a durable power of attorney is you are naming an agent. So this individual will be able to manage your affairs as if they were you. So handle your real property, your vehicles, your bank accounts, so deposit checks for you, pay your bills for you, even pay and file your taxes for you, if that ever became necessary. You don't have to assume your spouse can do so if you do get married, don't assume your spouse can do everything needed without one, even if your assets are joint. You always want to have this document in place because if you do lose capacity, you don't have a power of attorney, then again, that guardianship proceeding may have to happen and someone may have to be appointed as the guardian of your person to manage your affairs. Next up is your healthcare power of attorney. So this one is also where you're picking an agent, but this one is your healthcare agent. So this person makes your medical decisions for you. And this only goes into effect if an attending physician has determined that you do not have capacity to make or communicate your own healthcare decisions. So this individual will hire and fire doctors if you become incapacitated. They can decide on treatment options for you if you become incapacitated. They can also admit you into a long-term care facility if that ever became necessary. This document is especially important if, everyone drives every day. So if you're driving, you get into a car accident, you're in the hospital, you're in a coma, who's making those legal decisions for you? If you don't have this document in place, you're over 18, a guardianship proceedings going to have to be done so someone can actually have legal authority to make these decisions for you, especially if you're on any type of life prolonging measure. So that would be if you are in a coma and the doctor has determined you're never coming out of this coma, you're more than likely on some type of life support. So you can have a document called the living will that specifically says what happens to you if you are on life support, who decides when to essentially pull the plug. That document allows you to decide if you would want the person you've named to make medical decisions for you to do that. If you already know, hey, I'm in a coma, doctor's determined, never coming out of it, take me off. You can make that decision. Or there's a third option where you can say you want maximum treatment. That means you could be kept alive for as long as possible, regardless of what anyone says. So that's also something to think about and why you would want to have a healthcare power of attorney and living will in place. I had this little chart that I found on Atrium, and it just gives you a little bit of a picture description of what would happen if you did become incapacitated and you were in the hospital and someone needed to make legal decisions for you. So obviously you're the patient, you make your own legal decisions. But if you become incapacitated, then the healthcare POA, so that agent that you named, they're next in line. If not, then a legal guardian. So that's when the guardianship proceeding has to be done. Typically, it's not your spouse right off the bat. Typically, you'll have to have a guardian that is appointed for you to make those decisions. So this I already touched on the living will. So this allows you to state your wishes with respect to life support. So one of the situations is in a coma, and that's what I talked about a little bit earlier. Another situation, what if you have the advanced stages of dementia or some type of dementia like Alzheimer's, where you're conscious and you have no idea what's going on around you? At that point, some individuals will have to be on a feeding tube because your brain stops transmitting with your body and you no longer remember how to eat. So now you're on this feeding tube, you don't know anything that's going on around you, and you don't have a document in place that says who can make these decisions on what happens to you. So that can be really scary. And then the last situation in the living will is if you have an incurable or irreversible condition. So what if you have cancer, you've gone through all of the treatments, nothing is working anymore, the doctor is giving you days, weeks, months to live, you're on some type of life prolonging measure, so like a life support or something like that that's keeping you alive, you don't have capacity to make your own decisions anymore, and you don't have a legal document that says what happens to you. So a guardian is going to have to be appointed to decide what will happen to you, and you don't get to pick who that person is, the court does. So it can be scary. Now, what is a will? So off of the powers of attorney while you're alive. Now, this is after you passed away. So a will is a document, like I said, that states your final wishes. It allows you to name an executor. An executor is the individual that carries out your wishes through your will. So again, the person that gathers all of your assets after you passed away, and they make sure that your assets are properly distributed pursuant to whatever your will says. Like I said earlier, name guardians for your children. That's super important. And their property, decide how debts and taxes will be paid if debts and taxes come into play. And also decide, like I said, how your assets will be distributed. Do you want everything distributed among your 3 kids? Is one of your kids special needs? Do one of them require a special needs trust because they receive government assistance? So if your child receives government assistance that's income-based, such as Medicaid, you don't want to leave them an inheritance, because now if they get this inheritance, it could disqualify them from the government assistance that is helping them live. So those are some things that you should be thinking about. A will does not avoid probate. So typically what happens with a will is that your executor will take your will, like I said, to the courthouse. It gets filed, they get a golden ticket that says they are the executor, and then that's how they can start managing your assets. Typically, probate takes between 6 months to a year. It can be tedious, it can be easier. It kind of just depends on what assets that you have. With the COVID right now, it used to take 6 months to a year pre-COVID. Right now, it's possible it could take more just because you can't meet in person as much. But it just depends on the county that you're living in. Smaller counties, it's usually faster, believe it or not, in smaller counties than it is bigger counties, especially Mecklenburg County. Mecklenburg County, it tends to be understaffed, so things tend to take a little bit longer in Mecklenburg County. So a trust is also a document that you can consider. So a trust is a legal agreement between a grantor, so that's the person that contributes the assets, that would be you, a trustee, who is the person that you are naming to manage the assets, and then the beneficiaries, the persons that are benefiting from the trust. It provides management for assets during your life and also after your death. If you have minor children, you want to make sure that your estate plan includes a trust, because if you were to leave assets to your kids outright and they're under the age of 18, a guardianship proceeding has to be done for them. So someone has to be appointed as the guardian of that money for the benefit of your kids. And again, that could be someone that you know is not good with money, but the judge, for whatever reason, thinks that they would be a great guardian for your children. And now this person managing your assets for the benefit of your kids. A trust is often essential for several reasons. I kind of just touched on the big one, but your child won't need to wait months for a probate court proceeding to be finalized, because the assets go into the trust. Your trustee, the person you've named to manage the assets, can start managing the money right off the bat once the trust goes into effect. It ensures that a trustee is in place to manage the assets right away if the parent dies or becomes incapacitated when your children are still young. It also allows the trustee to hold the children's assets in a trust for their benefit until they reach a certain age. So let's say your kids are 10 and 12. Well, we don't want a 10 and 12-year-old to get all of these assets right off the bat. Probably not even an 18 or 21-year-old, because 18 going into college, 21 just getting out of college, and probably not as responsible as they would be at maybe 25 or 30. So a trust allows you to say, these assets, once my child reaches the age can manage their share of the trust themselves, because I feel like they'll be responsible at that point. And then that's when your kids, if they are responsible, can manage that money themselves. But until they reach that 27 age. It's just a document. It allows the assets that belong to trust, probate. It's definitely a lot easier way to handle the assets that you have. Manages great flexibility. It avoids guardianship, facility, and probate. It's a good tax planning tool if your estate is over a certain amount. Also provision of assets for children that are minors. Okay, I'm back. It seems like after a couple of minutes, it just doesn't want me to keep talking. Okay. I need to be made host again to share my
Okay, 1 second.
PowerPoint. Oh.
Oh my gosh, I need this so much.
And y'all just let me know when the slide shows up for you guys.
Hey, you ready?
Awesome. So other tools for estate planning. So jointly held securities and bank accounts. So if you have at least two individuals that share ownership, this is what I talked about earlier. If you own the property as survivors, the survivor would automatically receive the assets that are held in that bank account or security. Joint property also is protected, may be subject to creditors' claims. It may avoid probate at the death of the first spouse if you have joint assets, or if you have joint assets with, like your brother or your sister. Sometimes people will have their brother or their sister as a joint on their checking account or something like that, or they own property together. If you own it jointly with right of survivorship, it allows that property automatically to pass to the other individual. You don't have to worry about estate taxes. So North Carolina does not have its own estate tax, and then you don't have to worry about federal estate taxes unless your estate is over $11.7 million. Most people are not there. So you don't have to worry about estate taxes if you are under that number. So jointly held real estate, at least two individuals share ownership. It can be different in proportions. All owners must consent to the sale of real property. That's typically what will happen if you own property with someone else. May be held with right of survivorship, like I said, and then that would reserve any lifetime rights that you have to that property, because if you're the survivor, you automatically get that property. Other long-term care insurance is something that it's a hit or miss. Some people get it, some people don't. It provides a source of income if you were ever to be in an assisted living or skilled nursing care facility. So if you've ever heard of horror stories where, someone goes into a nursing home and then Medicaid takes their parent's house, usually long-term care insurance can provide protection for that. It's not income and it's not an asset that's dependent on government benefits. It may allow you to also stay in your home longer, because if you have this, you may have enough money to pay for someone to come into your house rather than having to go into a nursing home. Life insurance is a big one that everyone should have and think about. It provides a guaranteed source of income that can support either, your kids. If you get married, a spouse, it can make sure that money is provided for your kids or your spouse in the event that something were to happen to you. It's a tax-free way to transfer wealth. It usually does not pass through probate, like I said, because it has a beneficiary designation. So if you have a trust for your kids, typically the trust would be named as the beneficiary of the life insurance. And that means that then that money can pass to your kids through the trust, and it's tax-free. Pensions and retirement accounts, again, typically do not pass through your will. It goes right to you have named as your beneficiaries. And again, if you have minor kids and you set up a trust, the trust can be named as the beneficiary, and that ensures that that money can go to your kids properly. So what should you now that I have explained everything to you and given you a lot of information, the first step is to identify what your goals are. So what are your goals? You want to make sure that a guardian is going to be appointed who you would want to be appointed for your child. You want to make sure that your assets properly pass to your child. You want to make sure that your business is handled properly. You want to make sure that your assets are not going to pass to whoever the state says, because the law says who your heirs are by law. You want to have a will that says exactly who you want your assets to go to. The second step is to identify what your assets are. So my recommendation would be you take out a piece of paper, you write down all of your assets. Some people say, I don't own a home, so I don't have assets. Well, if you have a car, that's an asset. If you have a bank account, that's an asset. If you do have a life insurance policy or retirement account, that's also another asset. So all of those things will pass upon your death. So you want to make sure that you have a good understanding of what your assets are. How you own those assets is also another important thing. So if you own a bank account together with like your mom, you want to make sure that you understand what that means, where your assets are located. I always recommend to my clients that you leave a list of your assets for whoever you name in your estate planning documents so that they understand everything that you do have. Typically, your will just be generalized. So it doesn't specifically list your assets because you'll probably acquire more after you've done your will. So everything is generalized. A list is very helpful. I also recommend to my clients that you leave a list of username and passwords with your documents. So that if someone needs to get access to like shutting down an email account, a Facebook account, something, getting access to your phone, it's a lot easier if you have those username and passwords written down for them. And then my last recommendation would just be to sit down with a lawyer, a financial planner, or a trusted advisor to determine what tools work best to accomplish your goals, because everyone is different. It's not a blank, estate planning is not a blanket thing. Everyone has different goals and needs and family dynamics, and you want to make sure that your estate plan is done properly and meets whatever your wishes are. And that's it for me.
That was really good. I think one of the biggest things, Samantha, is as a single mom, like I never got started with estate planning because I always thought, like, I don't really have any assets. And so I love that what you mentioned about like it's even like small, it's like small things that you don't realize are assets, and also you can build on it. Like you don't have to like have a whole bunch in order to just get started. It's just about organizing and setting up everything. So I love the information that you presented, and I really appreciate it.
Yeah, that was good stuff.
I have a quick,
Yeah, of course. I really appreciate you having me on today too.
I have a quick question about the house thing. I've always heard that people should put their kids on their house title and to make sure that it passes on to them. Or is that something you would do in your will? Like, do you have to put their names on the house, or would that be a will thing?
I did not think about that.
So real property in North Carolina, if you state that, if your kids are your beneficiaries through your will, the will acts as a deed in North Carolina. So that means if something happens to you, and say your kids are 26 and 27, and you leave everything to them, now your will, once you pass away, acts as a deed. And it says that your two kids now own this property, and they can decide whatever they want to do with the property. If you put your kids' names on the deed now while you're alive, there's pros and cons to that. The biggest con is that property now becomes an asset of your child. So if they get into a car accident and they get sued, that asset is now a possible part of that lawsuit for that car accident. And that's your house. So you could possibly be kicked out of that house if the lawsuit is big enough. So that's a big con with naming someone else on your deed.
Now they gonna get my house taken away.
Yeah,
The house taken away.
that was good.
All right. Any other questions?
I have a question about the guardianship thing. How does that work if you aged out of foster care? Like, who is legally considered your guardian?
If you're 18 years of age or older, that you don't have a guardian, you're considered an adult.
Oh, okay, so if something was.
Yeah.
It would just be like nobody, like, no
Mhm.
assets,
Like,
no
for
assets
you?
would go to anybody, right?
Well, yeah, she was basically saying you have to go to court. The court would have to provide somebody to have like guardianship, because somebody has to give that. So in your will, you will have to set that up, so you won't have to go through that process. So like, if something happens to you, your daughter will get that instead of going through the courts and then they picking somebody.
I don't know, this sounding kind of, that's.
If
because
I'm
my
right,
daughter is
am I
special
explaining
needs.
it right, Miss Samantha? Because I don't want to tell her wrong.
Yeah, my daughter is special needs, so she did mention like.
Yeah.
Yeah, so like, and she gets assistance, so.
Yeah.
Yeah. she
So does she require assistance throughout the day? Like if something happened to you, would she need a guardian even if she was over the age of 18?
Yeah, she's like in 5 different therapies and she sees a lot of doctors, so like she can.
Okay.
Yeah, but she has to do her therapies and she's not gonna be able to live on her own when she's of age.
Okay.
So.
Yeah. So when you have a child that has special needs and then also receives government assistance, typically you want to set up a special needs trust. So this type of trust specifically states the money that's held in the trust is not to affect her medical or her government assistance that is income based. So it avoids her from losing any assistance that she may have. it also names a guardian for her, even if she is an adult, to make sure that you've decided who would take care of her if something happened to you.
Okay,
Okay, yeah.
That's good.
That makes sense.
That is really
thank
good.
you.
Yeah.
Yeah, because because in your situation, even if she's over 18, she's still gonna need a guardian. And then if, something were to happen to you, you would still need a guardian for medical or financial decisions if you haven't named someone, because you haven't given anyone legal authority, and without the court granting someone guardianship over you, no one has legal authority to make your decisions.
So this is kind of an off question. Diamond, were you done with your question?
Yeah,
I have a question. We have these parents that are now aging. I just have an off question about that. So how do we care for our aging parents? Even if they are not kind of with it, like what do we do? How do we protect them? I just don't know.
Well, so they should have, depending on their capacity, they should have documents in place. If your parents have a healthcare power of attorney saying that you are their legal guardian, the one that's supposed to make medical decisions for them, if they're in the hospital, the doctor is going to look to you and you can make those decisions. Same thing with a financial power of attorney. If they're getting up there in age and you don't feel like, they're properly managing their finances, and if they have a financial power of attorney that names you, that gives you the ability to help them with their finances and make sure that they're not, frivolously spending their finances. For example, I had a woman who's 89. She was going on QVC every single day and just buying something from QVC every single day for a year. So her house was full of things from QVC and her kids had no idea. If they had a power of attorney, they could have helped her and made sure that her finances were preserved and she wasn't frivolously spending them like she was.
Now, what
And
if,
then with a will, it makes sure.
I'm sorry, I cut you off. I'm listening.
No, it's okay. You go.
I was just gonna ask, like, what if they don't have a power of attorney and they're not interested in getting it, but they're making really, like they're doing the shopping thing? What if they're sending money to men in Africa?
Yeah.
Like, what if all of that is happening and how do you protect them? Especially with, when their mental capacity is not where it was. So I don't know how to support someone that doesn't want the support, but they need it.
So if the person does become incompetent, where mentally they're losing their competency, you can have someone determined by the court that they become incompetent, and then you can become their guardian. And then that way you can manage their finances and their healthcare decisions for them. So that if we're at that point where they're not going to have capacity to make estate planning documents because they're just not with it anymore, and you're worried about maybe signs of dementia or something like that, typically people will have to be appointed by the court that they've lost capacity, they're incompetent, and someone is appointed to take care of their decisions for them.
Oh, that's a good point. Like my mom, like I'm thinking about that.
Have you seen that movie? I have a question.
I'm thinking about that.
It's
My mom, like my mom's
basically what she's talking about.
Yeah.
So what now?
It's a movie on Netflix called I Care a Lot.
Oh,
And what she's talking about is basically what somebody would do in that situation you was just talking about, where you would have to go to the court and the court would order somebody to take care of all your assets. And in the movie, that's what happened, but she was no good.
She was no good.
Yeah, she was just stealing their money and stuff, but
That's also the same thing with Britney Spears right now. If you watch her documentary, her dad has a conservatorship over her because so that's kind of the same thing where
I have a question, please. Okay, so like.
What's up?
What, okay, you're so eager. Okay, so what happens if, like, let's say your child gets disability, but you as the parent, you're not her, payee? So the payee is someone else, but something happens to you, but they go live with their dad. So how would that work? Do they?
So it's a It depends on the disability. If the disability is not income-based and your child inherits from you, the disability shouldn't be affected. If the disability is income-based, it's possible that they can lose that disability money because now they've inherited these assets. And this is only if it would be outright. If it went into a trust, we wouldn't have to worry about it because the money goes into the trust, it's covered, it's not going outright to your child, and it's not considered income for that disability. It kind of just depends on what type of disability they have, if it's income-based or not income-based.
Okay. That's it.
It's a lot to think about.
Yeah. I mean,
It reminds
Yeah, it's a lot.
It's good stuff though. Thank you.
that was good, Samantha.
All
Thank
right, awesome.
Thank you.
Bye, ladies. I hope that you have a great rest of your time.
resources in terms of like how we contact you, any kind of information that you reference, even your slideshow, I can include it in the information I'm gonna send the ladies.
Okay, great. I can send you the last slide from my slideshow via email if you want me to.
Thank you.
All right, ladies. I hope you have a great rest of your time. Bye.